Will Donald Trump even be able to be on a ballot, whether or not it's the GOP primary or the presidential election? That's still an undecided question, but we have just taken a major leap forward in getting an answer. My name is Dina Sayegh Doll within the Meidas Touch network. Let's break this down. Now, Lawrence Caplan, a tax attorney in Florida, decided to file a motion. He is among the first to file a motion. We expect there to be many motions in many states regarding this issue because it's a very serious constitutional issue, but he is one of the first to file. And he's essentially asking the court for declaratory relief, asking them to make a decision. Essentially, is Donald Trump constitutionally prevented from seeking a second term as president because of his involvement in the rebellion and insurrection of January 6, 2021. Lawrence Caplan's filing is very eloquent, addresses all the legal issues. Up front, he addresses standing. You know, you have to prove when you're putting forward a case that you have enough of a connection to the outcome to have standing, that you're essentially the right person to bring the suit. Otherwise, somebody else should bring it. And he's saying he's participated in presidential elections for the past 12 years, that he's a legal resident of Florida. I think that should definitely qualify as standing. And I think that's part of why we're going to see other motions, because I think proving standing is a relatively easy hurdle in this situation, because we all as voters have a vested interest in whether or not the Constitution is followed. We would be essentially the best people to put forward this kind of a lawsuit. So he discusses standing, he pushes that aside, and then he goes to the crux of the issue of whether or not Donald Trump violated Section 3 of the 14th Amendment. I'm going to read from you exactly what Section 3 of 14th Amendment says. We hear a lot of a discussion around it, but just as a reminder of what the actual thing says, it is specifically a disqualification from holding office. It's not the same thing that talks about what somebody needs to be president, right? Like you have to be born here. It's not under that section. This is a specific section related to being disqualified from holding office. And it came about because of the Civil War. They didn't want people who were involved in the rebellion of the Republic to then hold office, because they were proven to not really care about the Constitution and the United States of America. And so they wanted to disqualify them from holding office. So it is its own separate section. And it essentially says that no person shall be a senator or representative in Congress or elector of president. That's where we qualify there. And vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath, which obviously President Trump did, as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may be a vote of 2/3 of each house remove such a disability. So even in this article, in this section, they give a remedy. They say you cannot hold office if you've already taken an oath to uphold the Constitution, and then you essentially don't uphold that Constitution, then we don't want you in office, right? And so this is exactly applicable to this situation. Trump as president, had an oath to uphold the Constitution, decided he didn't want to. Now even says if he's elected, he's going to abolish the Constitution, some really kind of crazy stuff. And this is exactly what the Constitution is trying to prevent happening, is if you've already taken the oath and you didn't follow it, we're not going to give you another chance, essentially. But they do say that if 2/3 of each of the House decides that you can still be in office, then we'll go ahead and let you be in office. So they give themselves a check there. And I think that's going to be important as this case and others like it end up being litigated. this is most likely going to go to the Supreme Court, because I think it's a very high likelihood that we're going to see different opinions out of different circuits that contradict each other. I imagine, we might see one out of the Ninth Circuit saying that Trump cannot be on a ballot, and perhaps one in, let's say, the Fifth Circuit or a conservative circuit saying he can. And then that has to then be resolved by the Supreme Court. The only way I don't see it going to the Supreme Court is if all the courts agree. In an issue like this, I think it's likely we may see some sort of disagreement. But I think something that will help when it gets litigated is that this article allows for an exception to it. It's in there. The exception is if the people in the House, 2/3 of them, decide the person should be able to take office, and they should be able to take office. It's kind of saying, we don't think you should hold this oath, but if the people who have worked with you or the people that know you disagree, then, you can go ahead and do it. Obviously, we are not going to have a situation where 2/3, unless this, right now there is not, right, in each of the houses, 2/3 who would be willing to let Trump hold office. So this exception couldn't be triggered, let's say, before the 2024 election. That's just not going to be possible. But I think the fact that it allows for the exception in there is helpful for the case against having Donald Trump be on the ballot. And in his motion, Lawrence Caplan refers to Michael Luttig, the former justice, he's conservative, and Lawrence Tribe, the constitutional Harvard scholar, who's a liberal. And the two of them have gotten together. They've written opinion pieces talking about how they think that the insurrection is separate from any sort of conviction around whether or not that you don't have to be convicted. It's the act itself. The article there, and I just read it to you, doesn't talk about convictions whatsoever. And it's true, other parts of the Constitution, they talk about, convictions. Like if you have a conviction, then you can't vote. They talk about that in those terms. But the fact that they don't in this particular section means that a conviction is not necessary. It's the act itself. Very persuasive writings. And we will see amicus briefs from those two, I imagine, in cases, perhaps this one and other ones that get brought, with their kind of knowledge being very persuasive as these cases move forward. So again, this is one of the first filings to finally put this to the courts. We've heard a lot of discussion around this, but regardless of this, the criminal indictments, the criminal charges, when the trials happen, whether or not he's convicted, regardless of all of that, is this separate issue of, is the act of what he did on January 6th, calling everybody to the Capitol in order to prevent the counting of the votes and this insurrection, and then failing to send in the National Guard when they were invading the Capitol and disturbing the votes, that this is in itself an act of insurrection that makes the person ineligible, and specifically Donald Trump ineligible to be on a ballot. It's a very important ongoing legal issue that we will be continuing to follow here on the Meidas Touch Network. Follow us on MeidasTouch.com and me at Ask Dina Doll 1.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at Meidas Touch to keep up with the most important news of the day. What are you waiting for? Follow us now.